Hi friends, today we are going to discuss about role of police and magistrate under Mental Health Care Act of 2017. I am Dr. Suresh Bharatmat, Professor of Psychiatry, Head of Telemedicine Center, Head of Forensic Psychiatry Unit at NIMANS, Bangalore. Before I start my presentation, I would like to have a disclaimer. This presentation is for academic purpose only. This is not for legal opinion. If you would like to have a legal opinion, please do contact an advocate. Mental Health Care Act of 2017 was passed on 7th April 2017 in order to protect the rights of persons with mental illness during the provision of services. Under this legislation, there are some duties and responsibilities casted upon police and the magistrate. In this video, we are going to discuss that. Section 100 discusses about the duties of the police officer. Any police officer in his jurisdiction finds a person who is wandering at large and believes that he has a mental illness and he is risk to himself, risk to public, or also he is unable to take care of himself. In such a scenario, the police officer in charge will take him under his custody and inform him and also to his NR. And immediately he will take him to the nearest public mental health establishment. And the doctor in charge of the public mental health establishment will decide whether he will be admitted under 86, 89, or 87, depending upon the situation. By chance, if the medical officer finds that the person doesn't have any mental illness, he will be handed back to the police. And the police will do accordingly, either dropping him to the residence or else the person's choice. In case, if a person with mental illness is admitted and whereabouts of his family members are not found, now it is the duty of the police officer to file an FIR of missing person and to trace the family members and inform him about the person with mental illness whereabout. At the same time, if any person comes to know that a person with mental illness has been ill-treated or neglected, will report to the police. Similarly, if any police comes to know that a person with mental illness has been mistreated or ill-treated or neglected, shall report to the magistrate. Now the magistrate has two choices. He either can order to produce that person with mental illness in front of him and deal him according to the section 102. Section 102 discusses about the admitting the person with mental illness to the public mental health establishment. In this section, the magistrate has been given power to admit a person with mental illness for not more than 10 days to a public mental health establishment. And after 10 days, the psychiatrist or the medical officer will decide whether he will be admitted under 89, 86, or 87 accordingly. To conclude, my dear friends, Mental Health Care Act clearly defines the role of police. A wandering mentally ill person will be taken into custody by the police and will be admitted to the mental health establishment. If the person with mental illness do not know the address and whereabouts, it is the duty of the police officer to file a FIR of a missing persons complaint, and trace the family members. And if a person with mental illness has been mistreated or neglected, either the people or the police has to report to the magistrate. The magistrate has a power to remand the person with mental illness to the public mental health establishment for not more than 10 days. After 10 days, the medical officer will decide how you will be treated as per the legislation. My dear friends, if you like this video, please do subscribe to my channel. Thank you very much for your valuable time. Stay safe.